Hello, everybody, and welcome to the next session. I hope you're all ready. I hope you've had dinner or lunch or whatever it is, and everybody's back on track. So welcome to the next session that's called How to Live on the Moon and Mars, Human Rights and Governance Considerations. I must say that's a totally different topic, and I'm really excited to hear about it because it's far away from my field, and I think most of us are really excited and will have a lot of questions for our speakers. So today's program involves two speakers. That's Thomas Cheney from the UK, from the Open University, and Antonino Salmeri, who's currently in Sicily, but he's usually working in Luxembourg, which is really close to where I am in Germany. And then we have Deepika Jeyakodi, who prepared a wonderful workshop for all of us. And I hope everybody stays in the channel to participate in that, because she really has some fantastic ideas on things to discuss. So yeah, let's get started. And the first speaker is Thomas.
I'm going to be giving you, as my title of my presentation, Space Settlements and Space Governance. And so I'm going to be giving you a very brief overview of sort of what is space law, particularly as it applies to space settlements, and then, but also talking about the sort of big complex legal issues in international law for state creation and all the sort of challenges. Obviously, I've only got 20 minutes, and these are big topics, so that it's going to be a very brief, quick-fire overview of them all. But it should give you sort of a flavor of the challenges and problems that we have to face when thinking about some of these issues. So to start off with, what exactly is space law? I always enjoy that question, because the response is pretty much just as it sounds. It's law governing human activities in outer space. More specifically, it is a subset or a special regime of public international law. If you really want the Latin term, we call it a lex specialis. And essentially that means it's a specific area of focus of international law with a specific rule set for certain types of activities or certain areas, so geographical areas. But it's important to remember that it is part of a broader international law. So we have 5 major space treaties. These all came out of a UN process. And these are, as you can see on the screen, the Outer Space Treaty 1967, that's the big one, and I'll be going into more detail about the specifics of that. But then we've also got the Rescue Agreement, and that details rules and conditions for the rescue and return, not just of astronauts, but also of space objects. And we've got the Registration Convention, which is a very important sort of procedural treaty, which means that we know who is responsible for all the space objects that are in outer space, because we have a registry, or at least in theory. The Liability Convention details the rules for who's liable for what and responsible for paying for it. And then we have the Moon Agreement, which is quite a controversial treaty in international law, largely because it is predominantly rejected by the international community. But there are, well, I think we're up to 19 states that are party to the Moon Agreement, and of course Australia is one of those. And it details specific rules for activities on the moon, at least for those states that are party to it. As I said, all of international law applies in outer space. This is now accepted as a general rule of international law, but it is also specifically stated by the Outer Space Treaty. And so that means that the UN Charter, all of the international human rights laws, things like, apply for activities in outer space, but you also have recourse to things like the International Court of Justice for dispute resolution. We also need to be aware that there are numerous what we call soft law instruments that apply in outer space. These are non-binding international law. And basically what that means is these are respected agreements for rules of behavior, but they don't have legally binding force. People adhere to them because they recognize that it's a good idea to adhere to them, or there's kind of an element of peer pressure in doing so. As I mentioned before, there is a UN committee that deals with space activities. This is the UN Committee on the Peaceful Use of Outer Space. It meets in Vienna, and it has a legal subcommittee as well as a scientific and technical subcommittee, and deals with a whole host of issues. We should also think about the International Telecommunications Union, which deals with regulation of radio frequency, and that's everything. I mean, they started as a telegraph regulation agency, now they regulate geostationary communication satellites and everything in between. The specifics for the Outer Space Treaty, this is the big deal. If you only know one bit of international space law, the Outer Space Treaty is the thing to focus on. It has been described as the Constitution of outer space, and that basically is just shorthand for saying it's a big deal, pay attention to it. But it's the framework agreement that everything else sort of branches off of. It's the thing that you really pay attention to. Also important to know is that many of its provisions are now considered to be customary international law, which means a whole bunch of things to lawyers, but essentially it means that even if you're not a party to the Outer Space Treaty, you are expected to adhere to those principles. And some of the core principles, particularly for the sort of questions we're dealing with now. So Article 1 of the Outer Space Treaty says that outer space is free for exploration and use by all states. That's important. That means that any country can go into outer space and make use of it, although we do have plenty of arguments over what use means. Then we've got Article 2 of the Outer Space Treaty, which is another nice, big, important principle. And this says that states aren't allowed to appropriate any area of outer space. So you can't claim territory on the moon, for example. Again, this is going to cause problems for space settlements, as I'll come to. But it's one of the big fundamental principles of space law and makes it quite different from a lot of other areas of international law. However, we are also discussing what does non-appropriation actually mean. And in terms of things like space resources, we're sort of deciding that, well, it means specifically territory. It doesn't necessarily mean resources. Then skipping ahead a couple of articles, we've got Article 6. This is becoming an increasingly important article because it says that states are responsible for the activities of their nationals in outer space. And so that's why, for example, the UK has published laws saying that if I want to do anything in outer space, I need to get a license from the UK government, because the UK government is responsible for whatever I do up there. So they want to make sure that they have some mechanism for keeping me in check. And the same thing with it goes. SpaceX will have a license from the US government, and so on and so forth. Also important to remember is the Article 8, states retain jurisdiction and control over their space objects. So despite Article 2 of the Outer Space Treaty, outer space is not a sovereignty-free zone. States do have a way of exercising control over what goes on in outer space. It's not a sort of Wild West free-for-all, and that's particularly important. But it also is a way for states to exercise control over space settlements, which I'll come to. And then finally, for Article 12, we've got specifically says that stations on celestial bodies are allowed, which again is important when we're thinking about space settlements or what have you. The Outer Space Treaty does have scope for these sorts of facilities to actually exist. Briefly mention the Moon Agreement. As I said, it is regarded as a failed treaty, although it's important to know that it's not a dead treaty. We are having new states accede to it, and there are a couple of more who are rumored to be joining it. And obviously, Australia is a party, so if you're an Australian, then the rules of the Moon Agreement are quite important for anything human wants to do. One of the big ones and the bit that gets controversial is Article 11, which says that the moon and other celestial bodies are the common heritage of mankind, which is language that's similar in the Law of the Sea Convention. And the big thing that this means is that there needs to be a legal regime for space mining if and when it becomes feasible to do so. This is one of the reasons why it's getting talked about a lot now, because people are actually starting to look at doing space mining. Then thinking about terms and concepts that are relevant for outer space. One of the big ones is this concept of space object. In short, we're essentially talking about a spacecraft, and space objects can be everything from Sputnik, as you see on the screen, up to the International Space Station is comprised of space objects. Unfortunately, the treaty doesn't really provide us with a particularly great definition of it. It's kind of broad and vague, and includes things like, well, it's an object that's been launched into outer space and its component parts. However, broadly speaking, we can talk about a human-made object that has been launched into outer space. And I will argue, as I'll argue in a minute, I think this is kind of an important concept for thinking about the future of territory in outer space, because much like ships at sea, space objects can serve as a kind of quasi-territorial conception. Now we're getting into the juicy bits, for the bits that I really like and find interesting. So state creation in international law is a complicated subject. It's one of those things that's more political than it is legal. And so there are lots of questions about, like, okay, well, when does a state come about? How does it come about? But as I've said a few times now, these rules are important, even in outer space, because all of international law applies in outer space. So how do we define a state? Well, again, it's sort of up in the air, and there are lots of edge cases that we can all point to and go like, well, that one doesn't really fit your definition, or why isn't that a state when it ticks all 4 of these boxes? But basically, we're talking about you need to have a territory. There doesn't seem to be a minimum or maximum size. I mean, after all, the Vatican is technically a state, and all the way up to Russia, Canada, and Australia, and everything in between. But you do need to have a sort of fixed territory. You also need a permanent population. Again, there doesn't seem to be any sort of minimum size. It does seem to be that kind of like permanence of the population, which is something like the International Space Station would struggle because, okay, while you do usually have about 5 or 6 people living there, they don't think of themselves as a people. They're Americans, they're Russians, they're Europeans. They're not international space stations, and they don't have like a connection to that as a space. You also need an established government. Again, what exactly that means varies, and there's lots of debate and discussion as to how strong established government needs to be, and obviously there's a lot of history with European chauvinism as to what actually constitutes government. But you do need to have some sort of political entity that can reasonably claim authority to be talking on behalf of the entity and have the actual ability to do it. Similar sort of thing with capacity to enter into relations with other states. Need to have diplomats. But as I said, there are various things there. Taiwan can tick all 4 of these boxes, but Taiwan is generally not considered to be a state, primarily because of objections from the People's Republic of China. And there are several other countries we can point to that could tick off 4 of these boxes, but they're not states. So it's not necessarily a situation of if you meet all the 4 of these criteria, you're a state. There's a bit more to it than that. Then we get into things like declaratory theory versus the recognition theory of state creation. And the declaratory theory is the one I favor and does seem to be the general acceptance within the international legal community, and which essentially says that when a state declares itself to be a state, it is a state, whereas recognition theory says that you need to be recognized by all the other countries. When you look at actual behavior of countries, the declaratory theory predominates. For example, the United States celebrates its birthday on the 4th of July, 1776, not the 3rd of September, 1783, when it was recognized by Great Britain. And so the US clearly supports the declaratory theory, at least in terms of itself. It's also important to consider self-determination, and that people have the right to determine their own future. This is one of the core values of modern international law, and sort of ties in with the general human rights agenda. And so it would be perverse, if you will, to sort of say that, no, you can't have a self-determination just because you're in outer space. We're going to keep you shackled to your terrestrial legal constraints. Then looking specifically at some of the issues for outer space, as I mentioned, we have Article 2 and the non-appropriation principle, which essentially says that states can't occupy territory in outer space. Well, if territory is one of the key determinants of statehood, then that presents a significant problem, because we've essentially said that you can't create states in outer space. But if we've established space settlements, which have a population, are we therefore not saying that they can't exercise self-determination because they can't determine that they want to become a state, because, well, you have territory, but you can't have territory. Similarly, you have potentially have issues with Article 1 of the Outer Space Treaty, which says that there's freedom of access to all areas of celestial bodies. But again, if you're establishing a settlement or even a state, the ability to exclude people from an area is one of the core things that go along with that. You don't have to let anybody who wants to come into your house, and yet that seems to conflict with one of the core aspects of the Outer Space Treaty. One of the things that I think is a potential solution for this is using the space object concept as a territory. Any settlement in outer space is going to be contained within a constructed object. You can't live in a tent on the moon. You'll die pretty quickly. So you're going to be living in a facility, and you can conceive of that facility as territory, and so not necessarily claim the actual ground it sat on. And while that might seem slightly absurd at first, especially when thinking about terrestrially based states, we do see examples in the terrestrial world. A perfect one is things like mobile homes, or I often use the example of your car. you probably don't own the parking space your car is sat in, and you don't need to own the space your car is sat in, but you do own your car. And while the car is sat in that parking space, you're allowed to use that parking space, but as soon as you leave that parking space, generally speaking anyway, somebody else is free to come along. And so we can conceive of space settlements in a similar sort of vein. There may need to be rules that established in order to say, well, technically you could move it. And again, we've seen things with the Romano population in the UK. There's been discussions about, well, what constitutes a caravan? If a caravan seems to be fixed permanently, does it cease to be a caravan? And there are special rules in place, largely because of the ethnicity of the people we're talking about, that say that they don't have to follow necessarily the planning permission rules for these caravans. And so there has been case law looking at, well, if they build a decorative wall around the base of the caravan, therefore they can't move it without demolishing the wall. So does that mean it's no longer a caravan? And they said, well, because you could demolish the wall and then move the caravan, yes, it does. So there are other ways of thinking about this, especially if we start to get creative. We can also look at the International Space Station as a potential model. Here is a piece of artificially constructed territory in outer space that could potentially serve as a platform for building a settlement. It's a different conceptual model. It would require some creative solutions, but we're capable of doing that. The picture on the screen is what is known as the Principality of Sealand. This was an anti-aircraft battery in the middle of the North Sea. And it was taken over by a group of people who then declared themselves to be an independent state. Nobody actually recognizes it as an independent state. There's one of the fascinating things that gets discussed a lot in the literature, but this is a sort of a perfect example of, why can't that platform there serve as territory? And if you are able to establish a community there, why can't it serve as territory? Just because it's artificially constructed doesn't mean it doesn't serve the sort of practical purpose that we use when talking about territory in terms of international law. So I think ultimately, once we start talking about settlements and things like that, we do need to consider a paradigm shift in not just space law, but international law in general. However, I think the core question will always have to be, what are the values that we want to maintain? What are the things that we're saying? These are the core principles. And I think, self-determination is one of the big, post-World War II principles that we've established in international law. Similarly, the human rights regime is one of the core pillars of the global governance system. And as far as space law is concerned, we do need to think about the non-appropriation principle. It's an excellent principle, and it was intended to prevent a kind of colonial land race in outer space. The Soviet Union and the United States didn't fight a war over who gets to own the moon, and that's a good thing, and we should recognize that value. But we should also recognize that it was not necessarily intended to stop humans going out into outer space and establishing communities, establishing societies. And if we don't allow the full range of political development for those societies, then that's just as unjust as if we had allowed the Soviet Union and the United States to colonize the moon and Mars. So as I say, there's a lot there. There's far more we could talk about on this one. I could go on about it for hours, but hopefully that's given you a good overview of the issues before we get into the more specific details. Thank you very much, and I'm always happy to talk more if anyone wants. I think I gave you my email address on the first slide. Thank you.
Thank you very much, Thomas. That's been a really amazing talk. Really interesting. I've got tons of questions, but I saw several questions in the chat as well, and we'll come to those questions after the second talk given by Antonino Salmeri of Luxembourg University. And the second talk will be about human settlements in space between space law and fundamental rights. Go ahead. I need to unmute you. You should be unmuted now.
Yes, thank you very much.
Yes, great.
So thank you very much. Thanks, Thomas, for the wonderful talk. My name is Antonino Salmeri, and today I'm going to follow up on the great talk from Thomas on the specific topic of human settlements in space between space law and fundamental rights. Just before I start, a little bit about my bio. So I am a doctoral researcher at the University of Luxembourg, where I'm pursuing a PhD in enforcement challenges of space mining regulatory systems. I'm also a graduate of ISU. I did SSP19 last year, and I am also I was also mentorship officer for ISP 20 this summer. I'm also a co-lead for Space Generation Advisory Council of the Space Exploration Project Group and of a dedicated team working on challenges for lunar governance. I studied in different universities all around Europe. And I'm also a registered attorney. Now, as we already intended when we started this discussion, we are becoming multiplanetary, right? This is the coolest development in space recently, because of course there is a strong interest in talking about and then pursuing actions to establish human settlements in outer space. This started already in 2015, more recently when ESA announced this concept of a moon village as a shared environment whereby human development can thrive. 2017, SpaceX revealed plan for developing a Mars settlement. 2018, as we all know, the United States announced the Artemis program as a multi-country and actually also a private-public program for the development of a human settlement on the moon, or at least for returning humans, and then follow up with a permanent basis over there. Likewise, Russia and China announced their own plan for a joint lunar research base. And in 2020, it has been estimated by Brightspace that there are 95 lunar and 11 Martian missions planned on the moon. If you haven't seen this chart, you can find it online on the Bryce Space Technology website. I would encourage you to look at it. It's really interesting. It gives you an overview of where we stand currently for Moon and Mars missions. The problem is there are a lot of developments, but where does international space law stand? Which is the question that we're trying to answer today. And it is great for me to talk about this after Thomas, because he already gave you a very nice overview of what space law is, how it is done. So I can really focus now on what is actually the issue in applying human rights in space, if there is an issue, of course. Now, the first point that we should keep in mind, as Thomas already explained, is that the key players of international space law are states. Right, so space law is made in UNCLOS, where only states can become members. You can have observers, which could be any non-governmental organization, but observers, although of course they are invited to participate, they do not participate in the sense that they can vote, although COPUS do not hold formal votes. It works by consensus, but they cannot contribute actively. They don't have an individual stand. They can just observe. So space law has been designed by states for states. When in the 50s and the 60s, there was the discussion for the regime of the space, the focus was on making states the center of international space law. And if you read the Outer Space Treaty, only states directly enjoy the freedom to explore and use outer space. Article 1 declares space free for use and exploration by all states. Then, of course, because there was already in the 60s a strong drive to allow for private entities to, have activities in space, it was said in Article 6 of the Outer Space Treaty that states are responsible and liable, Article 7, for all national activities in outer space. This means that if you are a private company and you want to do anything in space, you need a state backing you up. You need a state that will previously authorize and continually supervise you until the end of your activity, which means that, of course, you can benefit from space, but you cannot take initiative and go directly. You need someone to authorize you, and you need a state for that. Also, only launching states and certain intergovernmental organizations which have ratified the registration convention can register space objects and therefore exercise jurisdiction and control. Right now, if you launch a satellite, if you're a private company, you cannot register the satellite yourself. You need your country to send a diplomatic note to the United Nations and therefore register the satellite. And you will not have legally directly any jurisdictional control. This will be exercised by your country. So just to sum up, everything in space is designed to go through them. They are the focus of anything that you want to do. Then we ask the question, then what is the role for humans in space? After all, we send humans in space. We want humans to thrive there, not states. States stay on Earth, as it has already been explained by Thomas. So to answer this question, we may want to look at certain provisions of the Outer Space Treaty. Article 1, as I mentioned before, declares space free for exploration and use by all states. but it also declares that the exploration and use of space is the province of all humankind. Article 3 of Outer Space Treaty, as Thomas already said, restates the fact that international law is applicable in outer space. And of course, currently the regime of international law also includes the human rights regime. Article 5 is specifically, it's the only provision talking about actual humans, so individuals. It talks about the legal status of astronauts and especially the duty that each country which is party to the Outer Space Treaty has to assist them in any situation of emergency. So the first mention of humans in outer space, and especially individuals, is about protecting them, ensuring that they survive in space. And that makes a lot of sense because space is a very hostile environment. It's difficult to live in. And so the first thing that we want to ensure is that humans are safe. And then Article 6, which I already mentioned, that says that, yes, private entities can engage in space activities, but they need to do so under the authorization and supervision of states. So states are the key players of international space law that is granted, but they're not the only one. So that means that the regime of international space law has not been designed to have only states, but primarily states, which is a significant difference. So what is the role for humans in space? What do we draw from these provisions? Article 1 especially says that because the exploration and use of outer space, including celestial bodies, is the province of all humankind, it means that space is for everyone, not just states. So states are those who act primarily, but they need to ensure and make room for others, meaning private companies, individuals, non-governmental organizations. So they cannot claim we are the only one acting in space, but they need to ensure actually that in doing so, they still allow for all contributions, which are of course conducted in accordance with international space law. According to Article 3, in fact, human rights and, as Thomas already mentioned, self-determination may already apply in outer space. Article 3 is very broad. It specifically refers to the applicability of the UN Charter in space and to space activities. So we have a legal basis to say, well, yes, there is space law, but there are also other provisions which we need to take into account. Article 5, as we already anticipated, specifically restates that protecting human life is an absolute priority. All states have a duty to assist astronauts. There is a specific agreement on that, which Thomas mentioned, so the Rescue and Return Agreement. And this is an absolute priority. We don't want anything political or the fact that an astronaut is from another state to stay in the middle of saving a life, right? Everyone should make sure that if you can assist an astronaut in distress, in an emergency situation, you must do so, regardless of any other situation that you have. And in fact, thankfully, we didn't have anything so terrible that we had to record to this provision, but in principle, everyone agrees to that, and that's great. And then Article 6, private space activities need state regulation. That also means that the state cannot just say, yes, do whatever you want in space. They need to regulate, because Article 6 wants a state to ensure that whatever a private entity is doing in space will be in compliance with international space law. So as already has been said, space law is not a Wild West. Space is not an area whereby you can do anything you want. On the other way around, actually, it's very much regulated in the sense that there is a lot of norms that we need to take into account when planning activities in outer space. And that's for a reason, because we don't want to repeat in space mistakes that we've done on Earth. Space is a very dangerous environment, so we don't want to create any danger for the people in space and for the people on Earth. So that's why we got to make sure that there are rules, and these rules are for the benefit and interest of everyone. So, of course, sometimes you hear companies that demand, let's say, less regulation in space, or that they perhaps want to be left to establish the settlement as much as they want. This is, let's say, a very bold statement to make, because you need to do this by the rules. And this is not just for, the sake of the rules, but for the benefit of yourself in the first place. Now, let's apply these findings to human settlements. So to the specific idea of going to the moon or Mars and establish a human presence in there and eventually having a community staying over there. Now, for the purpose of this presentation, I divide now the two scenarios between non-autonomous settlements and autonomous settlements. And in the middle, there is a third scenario, which we'll also explore in the workshop that will follow this talk from Deepika, about, let's say, intermediate development settlements, right? Something that it's not yet fully autonomous, but it's not primitive, right? So it stands a little bit in the middle. Now, for non-autonomous settlements, given the law that we have right now, we make some initial assumptions, right? The first one is that lunar settles, I'm talking about the moon because, of course, it looks like the first environment where we will all experiment on these rules and how do they apply. Of course, Mars would be a little bit different, but it's also a little more in the future. So they will, for the purpose of making this more realistic, let's say, we will focus on the moon, but of course, mutatis mutandis, things can be applied to Mars as well. Now, people sending on the moon will have to follow the rules of their licensing states. That means that whatever they can do and whatever they cannot do will be in their license. This is, of course, talking about individuals or private entities. Of course, states will have to do differently because they are free to directly use outer space. They don't need any permission, but that's about state activities. Here, we're talking about human activities in the sense of what is the role of human settlers and human rights in there. Then states, in providing these rules, so in giving you a license, they have to ensure human safety first. So whatever they will allow you to do will be based on the fact that it is safe. If it's not safe, it shouldn't happen, right? Of course, we cannot be 100%, especially in an environment like the moon, but we must ensure safety first. Then states, because exploration and use of outer space is the province of all humankind, they have to consider also other applicable rights, right? Such as, for instance, the right to life, the right to protecting your body, the right not to be tortured, things that we call fundamental human rights. Now, those will have to be respected immediately. The fact that you are operating on the moon doesn't mean that you are not entitled to protect the integrity of your body or to enjoy the freedom of speech, things that belong to a human, no matter where you are in the universe, we could say, right? But then applicability of other human rights will expand, let's say, incrementally. So it will depend on how the settlement goes, what are the issues, what is the funding to guarantee certain rights. Let's say, for instance, the right to privacy, you need a developed settlement, of course, because at the beginning, in order to ensure safety, we will need to monitor what's happening on the settlement. And so to have your right to be completely on your own, we need to ensure that you could do so in a safe way. So that right will perhaps come later on. And the same goes with other applicable human rights, such as the right to property. Right now, we have a lot of issues with property rights in outer space. You can, let's say, enjoy property rights on resources extracted, but can you build a house on the moon and become the owner of the house, which would entail owning also the land below at a certain point, right? Because the right to property is a very established and strong right in international law. Those, of course, are questions that will change until the settlement becomes autonomous. So for things that are in the early stages, we can make certain rules. For autonomous settlements, then the question becomes much more interesting, but also much more complicated in international law. Because as Thomas already anticipated, it is about balancing or eventually deciding which one should prevail between self-determination of people and the prohibition of national appropriation. Now, Article 1, Paragraph 2 of the UN Charter states clearly the right to self-determination of the people, meaning that if you are an autonomous community living on a certain territory, you have the right to self-govern yourself, which is a right which is enshrined in every human being, the fact that every political community should be entitled to make their own rules. At the same time, we also have Article 2, which is about prohibiting national appropriation of space. Now, as Thomas already anticipated, one of the issues in interpreting Article 2 is we wanted to avoid colonization from states, but this perhaps should not stand in the way of impeding the development of a political community on the moon or on Mars, because this would ultimately prevent space exploration, which is in contrast with the purpose of the Outer Space Treaty, right? The Outer Space Treaty wants to foster space exploration to enhance human activities in space. And so a strict interpretation of Article 2 prohibiting anything that would ultimately raise to the level of appropriation perhaps need to be reconsidered when we talk about a very long future, to be honest, when you have a community completely independently living on another celestial body. Now, the question at that point becomes that on Earth, if you look at the history of self-determination, that's limited by state sovereignty. So important to keep in mind, self-determination is a fundamental principle, but it's not the fundamental principle. The fundamental principle of international law is state sovereignty. It means the state enjoy their sovereignty on Earth. And on Earth, in fact, you see that whenever a country that wants to self-determinate themselves using a territory of another state, then that doesn't work most of the times, because states have the right to exercise sovereignty on their own territory. So what do we do in space? Because in space, there is not territorial sovereignty, right? There is no one saying, this is my sovereign area, but there is also no appropriation. So the balance becomes, how important has been self-determination in international law, what have been the limits to that, and can we develop similar limits in outer space? Does it make sense to do so? Do we want to do so? Do we think it's in the interest of fostering exploration or not? Now, I have some thoughts about this that I could share also in the questions and hopefully in the workshop too. But the idea is that we need to be careful about this, right? We know that these two are two important principles. There are some scholars saying that without the non-appropriation principle, the whole system of space law would collapse. So we need to be very careful in trading that off for self-determination. We need to make sure that we preserve what we have done in the past instead of destroying it for building a different future, right? We want to be consistent with what we have done, although we want to expand. So it is difficult. That's why we are here, and that's why this topic is very exciting. Also, we have a good amount of time to discuss these things. As Bryce Space said, missions are starting, but they are in the very early stages. So before anyone will live on the moon autonomously, it will take some time. So we have the time to discuss, and hopefully we will engage in very fruitful discussion. The debate on lunar governance all around the world is spreading a lot, and that's great, especially for space lawyers, I must say. So hopefully with the contribution of everyone, we will make sure to do the right thing. Now, before I end, I want to give you some food for thought, which are questions for further reflection that you can keep in mind while doing while participating in the workshop. So the first question is for non-autonomous settlement. It is about what fundamental rights you believe should be immediately applicable in space, right? Would you say that the right to life, freedom of speech, right to, let's say, habeas corpus, as we say in law, so that you protect your body? What are the fundamental rights that you say, if I'm going to live on the moon, I want those rights? I will never renounce to those things, and we should never renounce. And then you have to make the other way around. What are the rights that you think should be and could be sacrificed in the name of ensuring safety, right? As I said before, privacy is a fundamental right these days, but when we have to ensure that you are safe on the moon, we will have to monitor you. And so you will have to renounce a little bit to your privacy, or maybe not, or maybe there is another way to do that. So think about it. And then questions for autonomous settlement. Again, the question is, which one should prevail between self-determination and non-appropriation, which is, of course, a question of how far do we want to go in space development, and how far do we want to have independent communities living besides Earth communities? This is actually the very final question that I have for you, because in the end, should an autonomous settlement be entitled to depart from Earth law at all? They are living on another planet. Let's not talk about the moon now. Let's talk about something more far away, which is Mars, right? To reach Mars, you need at least 18 months. Every 18 months, every 18 months, you need to launch, and then you need 6 months. So you need 2 years to go from Earth to Mars. Does it make sense that people on Mars live by Earth law at all, once they are able to live independently, of course? Can they be entitled to say there are no fundamental rights on Mars? We believe that Mars should be a dictatorship, right? Is this their right because they're living on a different planet? Should they be bound by what we think are fundamental rights? They could say, you're on Mars, things are different, we want to have a different society entirely, right? Or could they go even further away and say, there's going to be no sovereignty on Mars at all. We want to be completely a global community. We will establish a Mars state, which will have control over the entire planet. We will not have nations on Mars when we become independent. We want to have a different thing, or a 13th genus that we don't even know about right now. The question really is, can we on Earth decide how people should live independently on other planets once they have this ability? So at the beginning, I think we have this right because we are financing and sustaining the settlement. But once they become completely independent on their own, shouldn't this be their own entirely? So not just saying, yeah, you can determine yourself, but you have to live by public international law that we have on Earth. Does it make sense to further expand it up to going to international independent communities? So it's also a question of how far Article 3 of the Aerospace Treaty applies to communities that became independent, not just from another state, but from Earth. And so with that, I would like to thank you all for your attention. If you have any questions besides asking it here, feel free to email it to me or find me on Twitter, LinkedIn. I'll be happy to engage in the discussion, either within the university communities, ISU community, of course, very happily, SJC, everyone that is interested is much welcome to contribute to the conversation. Thank you very much.
Thank you very much. I'd like to thank both of the speakers for their really super interesting and amazing contributions. And thanks a lot for almost sticking to the time as well. We've now got 4 minutes left for a first maybe couple of quick questions, and then we need to do the rest of the discussion after the workshop. So the first question came from Shane Asher during the first talk, Thomas. And I will just unmute you, Thomas, so you can discuss. And then his question was basically means if you're Australian, you can't do anything on the moon. I'm not sure. Yeah.
Yeah. I mean, obviously, I can't speak for what the Australian government thinks its legal obligations regarding the Moon Agreement are. But that's one of the reasons why most states haven't signed up to the Moon Agreement, because of Article 11. There's debate as to whether or not Article 11 of the Moon Agreement acts as a moratorium on activity. Personally, logically, it does, but there are people who disagree with me, because it does say that you need a regime in place in order to be able to authorize that kind of activity. And one of the concerns I actually have is that it could lead to a fragmentation of the international space law regime, because we're already starting to see the United States is pushing its Artemis Accords. You could see Moon Agreement states recognizing that they need to do something to implement some kind of authorizing mechanism for their countries in order to not lose out. So it is a cause for concern. There's some rumors that we might see countries like Australia pull out of the Moon Agreement so they can sign up to the Artemis Accords. But I'm not aware enough of Australian space politics to be able to judge the accuracy of that. So yeah, it's complicated.
Okay, great. There's
Bergita,
another short one. Sorry.
If I may add to that, because I have a little bit of a different opinion than Thomas. Of course, it's a matter of debate, as he said. I honestly don't believe that the Moon Agreement establishes a moratorium. If you look at the Travaux Préparatoire of the treaty, there has been declarations that Article 11 is not intended to stop any effort in already, let's say, taking use of the resources you have there. It says that they have to establish a regime, that they should take efforts in order to establish a regime. But it never says that you cannot do anything, because that would be limiting the freedom to use outer space, which states want to retain. So there is discussion, of course, that's not written in stone, and I don't know what's the Australian government position, but just to say that fragmentation is a risk, as Thomas said, but we can coordinate still having different laws at the national level, because of course different countries have different national space legislation, and they have to still to authorize private activities. So there will have to be national law anyways because of Article 6. And before we create an international regime, it will take a lot of time. So in order to be able to start activities, at least in the early stages, I think having national regulation is a positive thing, so that we ensure that respect with space law is ensured. And I think countries party to the Moon Agreement should also be able to participate in that, so to authorize their own companies, of course, while they are preparing for an international regime. So they should go like on a parallel track. On the one hand, they can authorize, on the other hand, they need to make efforts to establish.
Okay, thank you very much. And now we've reached the time for the workshop, and I think we will clarify all the remaining questions after the workshop. See you later.
Hello, everyone. Happy to see that we still have good numbers, although it's quite late in another part of the world. Today at the workshop, we have an interesting workshop lined up for you. Before we step into that, a quick introduction. I'm Deepika Jeyakodi. I'm based in the Netherlands. I'm part of the Just Add Astra project that's championed by quite a few Australians, including Rowena, our host today. A lot of the discussions we've had today have revolved around how we will become an interplanetary species in the future. We've witnessed some very insightful presentations also from Thomas and Antonino just now. While the technical, scientific, or financial factors and questions are perplexing, there are also legal and governance challenges that we need to overcome in order to make living on another planet a reality. So space doesn't just become scientific and economic, it also becomes social and cultural. And if the future of humanity, as a lot of us here believe, if we think it's tied to the safe and sustainable use and exploration of space, it's necessary that the fundamental rights of humans, that they need to be interfaced with human activities in outer space. And that is precisely the message that the Just Ad Astra project tries to bring a common understanding around with different stakeholders in the field. So whether it's with the industry, academia, governmental agencies, or whoever it is. For us, the key message is that the protection of human rights is integral to the success of human activities in space. We've already had several questions from Thomas and Antonino, and probably they've triggered you to think about a few things. Some of the key questions that I had when I was developing this workshop was, to what extent Earth law should be binding for people who are living on another celestial body through different timelines? How can we create a sustainable environment in space for humanity to thrive, not just to survive, but to actually thrive? And what sorts of rights and obligations should these inhabitants or residents have? And in this session, we'll be looking to you for answers. And before I do that, let me start by sharing my screen. So today you will be put into different groups. We will shortly be sending you into different breakout rooms. You would have a 20-minute group discussion, and each group would come back to the plenary to present something. And then we will have a 5-minute wrap-up session in the end. You will be split into 3 groups with very simple instructions. The first group, let's call them the pioneers. You are representing 100 persons who are now out in space. You can choose to be in Mars or on the moon, and you rely predominantly on Earth for your sustenance. So this is group 1. The group team 2 would be the early settlers. So now you have a population of about 1,000 persons. You rely partly on Earth, and then you have your own resources and sustenance set up. And then group 3, you are the first space residents, let's say. So you are in a society of 10,000 persons who are self-sustaining. So this is the bigger setting. What you would be doing with each of the group for the next 20 minutes is to set the scene. So who are the people in your settlement? What does your demographic look like? What age groups do they belong to? What genders do you have? What professions do you have? Do you assign different roles and functions for the people, and how do you go about doing that? And who is responsible for taking care of them, or who is going to govern the society that you have? And of course, each group has to think about it from your own setting. So the pioneers think about this only in terms of the 100 people that you have, and the inhabitants and the residents, you think about having sustaining a population of 10,000. So you set the scene first, and then based on the scene that you set up and the population that you have, try to draw up a charter. So you need to pick out 3 to 5 key human rights that fit your setting, and have discussions with your group on what these should be and why you think you choose those 3 or 5 human rights. And once you're done with this, at the end of the 20-minute session, you will come back into the plenary. Within your group, please assign one or 2 persons to talk, to tell us about your charter and why you came up with this charter. And we give 5 minutes for each group to present their charter, and we'll have a round of questions. Does that sound okay? All right, so I think we are already in groups. If we have everyone back here, let's get started with team 1 then. Who would be presenting from team 1? What is your charter?
Shane was started it though, so he could do it. We didn't actually come up with anything very much because we weren't sure of our purpose. We couldn't work out whether we were 100 explorers or, correct me if I'm wrong, group, or we were 100, citizens sent there by a private resource-driven company. Or, I mean, we talked about having the basic. I looked up the UN rights, the basic right to life and security and safety, and what else, Shane?
I did note that the sovereigns would need to obligate any companies that sent people to basically satisfy a certain charter and obligation to look after the people with certain basic rights.
Okay.
Yeah.
So it would be your society, let's say if it is sent by a private party, you think it's more, the private party sets the rules for how these 100 people would work?
Well, there's a hierarchy of rules. So the sovereign obligates the private party to have certain rights guaranteed to the people. And we started to consider what some of those rights were. We considered, was there a right to return? Was there a right to not return?
That's interesting.
And was there an obligation to return or not to return? And also with respect to reproduction, we didn't know where we stood on that either. So it was unknown in almost every way as to the conditions upon which we'd been sent there.
Yeah.
We recognise that the majority would be considering returning, but that's not necessarily all. So there'd be a diversity of different positions and perspectives, and that need to be respected. We also considered the what we could say the non-performers and what you did or couldn't do with them. And we had no resolutions for any of them, but we determined that the sovereign should, at the outset, before they send them, set up a set of ground rules that we could seek to tinker with.
Yeah. And we looked at, I think we kind of, a few of us said the Antarctic Division, look at that polar base as being a model. You know, if it were a not-for-profit thing, it were a research or science exploration, or if it were exploring,
and there was
Antarctica.
Yeah, there was a distinction between Mars and Antarctica that we considered, and that was that in Antarctica, there's very little capacity for in situ resource utilization. So virtually everyone in Antarctica is there as a request of the sovereign.
Yeah.
Whereas eventually on Mars, utilizing the resources there is a necessity for life.
That's fascinating. I think despite you not having a fixed charter, you have quite a lot of interesting points that you brought up. I especially liked the right to return and the non-performance part, which is something that I haven't heard in any of the discussions so far. So as a space lawyer, I'm really curious to see where that leads us. Thank you for that. Shall we move on to team 2?
Yep, sure. So I'm speaking on behalf of team 2. It was mainly just Antonio and Maurizio and I talking about group 2 topics. So we were looking at a settlement of 1,000 people. So pretty much mid-game in terms of the colony. So at this stage, we've got 1,000 early settlers. We talked quite a bit about the governance as well, and in particular, what kind of law enforcers would be seeing, who would be in charge of the management of the local colony, and we pretty much determined that would be a collaboration both between countries and between Mars and Earth themselves. But I did note that there was it was making me think of, there's been various times either in Apollo 13 or with the space station where those remote teams have kind of like they've torn off their equipment and turned off the comms and done their own thing. So I think there's going to have to be a strong presence at that location itself, but then incorporating Earth as well. So we saw a lot of kind of mirroring what was going on at the space station in terms of the early law and governance. We also saw that there'd be quite a bit of base setup going on, so engineers and architects, and then fuel production would also be pretty high up on the priority list, and that kind of comes into human safety and crew return and being able to evacuate if something goes wrong. And then agriculture as well was another big one, needing food. And that kind of ties in with fuel production as well, for producing water. So you've got food and water being high priority. And I also threw in a bit of early science and exploration would be definitely going on at that stage. And of course, you'd need doctors and medical. Basically, day one is a given. So you've got a colony of 1,000 people, you're going to have some pretty serious medical infrastructure. So the focus really, we didn't feel would be on profit or industry. Like there might be a little bit of that kind of kicking up at that stage, but it would be more so on setup and survival, and maybe a bit of a transitional stage. And so then we had our kind of like priorities in terms of the rights and everything that everyone would want. So top priority was right to life. So obviously that covers quite a broad range of things. Anything from extreme as murder to just general rights of living beings. Second from the top was a respect for diversity. So we were talking about gender and race, those kinds of things. There should be respect in any regard, and even going as far as age, those kinds of things. And then the third was right to autonomous governments. So maybe not a full independence, but some kind of right to a localized governments at that point. And I think there was a fourth one, but I can't actually remember what that one was. But that pretty much covered what we discussed.
Thank you. Anybody has questions for team 2 from any of the other teams? Something that you would like to challenge them on?
Antonio, do you remember what the fourth point was there? Because I think we had a good one right when we ended it.
I think it was developing the concept of governance and the autonomous development. I cannot remember on the top of my head, but I think it was related to that concept that we are in a mixed environment, so we don't tend to be independent, but at the same time, we want to have our own ability to decide at least on small things, dispute resolution, those type of things. Those should be there. But perhaps Maurizio, you have some thought as well that you want to share. I'm
also curious that you mentioned that it's more about setup and survival instead of profit and industry. I'm just thinking out loud. If it is private entities that are sending people to Mars and to the moon to mine and things like that, they surely want returns on investment. So how do you balance that with the need that you need to look at the more human side, that you're thinking about survival over there instead of profits?
If I may step into this particular point, you see, private entities exploiting resources on Earth in our history so far are basically based, let's take an example, mining, okay, or fisheries or whatever, is based on the fact that a certain government of a certain country is assigning the license to a certain private entity to exploit whatever resource, at least according to the rules of this country, okay? You're allowed to go and mine there, you take gold, but you're not allowed to kill or to whatever, because they are the rules of the country. And I represent the country, I allow you. Now, to extrapolate this concept in space, on Moon or Mars or whatever, an asteroid, is much more complicated. First of all, because no country per se has sovereignty on any of the celestial body. So in my modest opinion, I'm not a lawyer, in my modest opinion, no country should be allowed by the entire humanity to enable a private entity alone to go and do and exploit. I would expect at least a kind of consensus on this point. And second, according to which country's law? In certain country, countries, certain things are strictly forbidden. In other countries, the same things are highly tolerated or even encouraged, and other things are forbidden. So it's very simple to say, okay, guys, you go, you open a mine, you take the gold, you sell the gold, and don't kill too many people, okay? Or don't do too much of that. But to extrapolate this from this very basic behavior on the moon, based on our history and our experience, in my opinion, is much, much more complicated from the legal point of view. It's easier from the engineering point of view than from legal point of view.
Fully agree. Thank you for that.
I think even sorry, from an engineering point of view, there's going to be a lot of reliance on that initial colony, and even just with 1,000 people, like I think that there'd definitely be the industry taking off at that point, but they're going to be very reliant on those initial colonies for stability and resources, and 1,000 people isn't a huge amount, so it's definitely going to be there. But I think that's why we focused on the survival and setup element, because I think it's still going to be in full swing with 1,000 people.
There's actually a really good example of such a colony on Earth, on Svalbard, Spitsbergen, which is in the Arctic and does not belong to any country at all. And several countries are playing there and mining there. First of all, because there's good brown coal, but also just to assure they have a foot in the territory. And there used to be a city called Pyramiden. It was a Russian city, and it was the northernmost settlement on Earth with more than 1,000 people. And they were mining brown coal and had school, hospital, and a lot of families there. And over the winter, they were entirely isolated. So if anybody wants to read up about that, they've already done that. And I think it's very comparable. You can also, by the way, travel there and have a look around.
With a Russian passport, no doubt.
Yes.
No, it's not on any country. You can just fly there with a regular flight from Oslo. I did it twice. So you fly to Longyearbyen, and then you take a tour to the ghost town Pyramiden, and you can just have a look at everything there. You don't need a passport for not a Russian visa or anything like that.
Wow, Bergita, wow. I just saw something a little while ago. NASA said it will pay private companies who can collect rocks and dust find ways to collect rocks and dust from the moon, and they'll pay them $25,000 for 50 grams of moon dust to kind of begin the lunar marketplace. And I actually think that the Americans passed laws in the Senate allowing private companies to go to the moon and set up businesses on the moon. So I think the loophole just correct me, Thomas would know, the loophole in the law is that privately you can do what you want. As a nation, you can't. Is that true or not?
Not really. The Outer Space Treaty governs the different states, so all the sovereigns. And they have the responsibility under the treaty to make laws for their citizens. So whether for their judicial persons, let's say. So if there is a private entity that's registered in the US or run by US citizens, then they are obliged by the laws that the state has adopted.
Oh, I see.
So even if the US is putting out different things, also with the latest Artemis Accords, they are trying to keep in line with what the Outer Space Treaty says. But of course, there's a lot of gray area. There are a lot of gaps that need to be filled with. And the very fact that we are having this conversation is only an example that we need to get the discussion going to make sure that we don't repeat the mistakes of the past. Yeah. So yeah, that's where it is. Okay, with this, just to make sure we keep it in time, I asked somebody from Team 3, the wonderful group that I worked with, to talk about what we discussed. Bergita, Srimal, I see Harjot as well. So if one of you could take the floor.
Oh no, I'm already chairing the session, so yeah. Shrima wants to do it. Okay, amazing, perfect.
Team.
We can all do it. Yeah,
Okay.
We'll do it together. You can do it.
So I think what we had was a settlement partially mining and partially in terms of a little bit of exploration and scientific activity. And we thought that they could coexist quite happily. I think we were moving towards around 2060, just as a model, roughly. I think in terms of, yeah, did you have? Yeah.
No, you keep going. You can speak for us.
So yeah, we had 2060 as the rough time frame that we I guess be there. We recognized that there'd be, I guess, more private enterprise moving in by this time, and it's sort of more self-sustained, I suppose, rather than such an interdependence on Earth. And I think our solutions very much reflected that. In terms of, if we move on to the rights, I guess, unless you had anything else to say about our model.
Now, I think one of the key things that we discussed was also about the population, where it was interesting because everybody agreed that it should represent different cultures, different genders, and so on. They're not just binaries. So that was something that I was very happy to hear about.
And having diverse age as well.
Mm.
Yes.
I think some of the interesting rights that were brought up, barring, of course, basic rights to life, was, I suppose, right to oxygen, to water, to food, which I think was a very interesting point that was brought up. I think we also considered perhaps medical care, emergency services as something. And as part of that, we looked at some of the important roles that might exist. So we were thinking perhaps mining professionals, would need medical professionals. I think people to prepare food, among other things, I guess. But I think one of the interesting points we took out of that was perhaps people going there could specialize in multiple things. So you could have someone who is a medical professional who at times would go and help prepare food or something like that, just to diversify the roles amongst the community. And I think that would be supplemented by use of robotics and utilizing that to, I suppose, bolster the capacity and I guess the limited capacity of humans to be conducting activities. Going back to the rights, I think that the UN Declaration of Human Rights might be a good place to start, but I think we were more discussing the basic rights that might exist. And I think wages
fair
also
work
came
conditions,
radiation protection. There were a lot of interesting things that came up.
Did you have anything else to add?
Bergita?
The question how we earn our money, if we do tourism, if we focus more on science or on mining. And then I think we also briefly thought about if we want to have money or not.
Right to reproduce as well, and whether that would be limited by resources.
Yeah, and by radiation.
Definitely.
So that was a summary of things. And of course, since we had robots helping us with some of the activities, it meant that we also get to go on holidays in Mars. That was also,
yeah, we found it super relevant if travel is easy or not. So it's two entirely different sets of things depending on how easy and cheap it is to travel.
Oh, a new right of return concept. If you return to Earth, would you have the right of return to Mars? So at the moment, none of us, well, the overwhelming majority of us don't have the right to go to Mars. But if you've gone to Mars and you come back, do you have the right to return?
No, but you have the right to go to Mars. You only need to buy a spacecraft and go.
That's it.
You have permission from your government.
You'd have the right to return, but you'd pay for another ticket.
Okay, so with that, let me...
I was going to say, do you have, if you go to Mars, do you have the right to come back to Earth? If you've come back to Earth, do you have the right to go back to Mars?
Yeah, I think that's helpful.
Is that what you're saying?
Yeah.
Both ways.
That's what Shane was bringing about. If you were all space lawyers, we would have such interesting PhD theses to read about. But anyway, so I hope this was, oh yes, a question from Harjot. What if you were born there? So we, I think within this group, we discussed having, Harjot raised the point that we could have an independent council. We also just discussed having a self-determined society. So a government from a government that is mass grown, let's say. Yeah, so there are multiple things to think about. I'm afraid we don't have all the answers yet. We are trying to see how the space law jurisprudence that's already been set out in 1968, which just says, okay, all of international law applies to space as well, how that takes into account the different human rights regimes that we have here. And this is a discussion which I personally think shouldn't be restricted to just lawyers, since it affects pretty much every function that we do, whether as a medical professional or as an engineer and so on. It's good to think about human rights by design. So whatever activity that we do towards our future in space, that we try to keep human rights, let's say, anchored to it. And with that, I would like to say thanks to the hosts for granting this session. It was wonderful to have these discussions with you. And if there are any questions, please feel free to reach me or one of the other space lawyers. And I'm sure there's a lot we can learn from you as well, because you're much closer to, let's say, technology and the people. So thank you.
Yeah, thank you very much, Deepika, for hosting this amazing workshop. That's been a lot of fun. And initially I thought, will it be a lot of fun? But then we had so many cool things to say and discussions going on that for me, it was a lot of fun, actually. And it's good stuff for science fiction novels, isn't it? So maybe we'll find some of our ideas in some novels in the future, won't we? Yeah, thank you for the amazing workshop. And now we still have some time left, I think about 20 minutes to continue our previous discussion. And there was one more question left in the chat from earlier, from Jonathan Clark, or maybe more commenting, but I take it as a question. He wrote, not quite correct, Shane. So Shane, it's for you. Shane, yeah, there you are. CSIRO are very keen to get into the, I have no idea what that means, ISRU space and analog research.
So what he's saying is that the CSIRO in Australia, which is our peak research body, is keen to, is currently researching in situ resource utilisation on the moon and looking at how they can do that.
Right. So that would make sense because, again, the Moon Agreement has not been drafted to stop things to happen until there is an international regime. It only says that when exploitation is about to become feasible, states should attempt to develop regulation for that. So in the meantime, you are, of course, entitled to exercise the freedom to use outer space, including to extract resources. The only thing is that countries having ratified the Moon Agreement need to take into account the purposes of the Moon Agreement itself. So Article 11 provides some criteria for the development of an international management, including the rational management of lunar resources, sustainability aspects. So provided that your national temporary regime respects those, then you're fine. So I think Australia could definitely engage into that, respecting these principles, and in the meantime, encouraging international development of rules.
Okay, yeah, that's great. Then I have another question for Antonio, actually. So you mentioned 95 lunar and 11 Mars missions. That would be a lot of dirt in our atmosphere. How about environmental pollution becoming a crime or as an aspect of law at all? Are there any thoughts about that? Or has anybody ever published anything about that idea?
Deepika, perhaps you want to take that. I'm not an environmental lawyer, but I definitely know the point. It's a matter of concern, but maybe Deepika, you have some more thoughts than I do.
So there are different paths to, let's say, space lawyers dealing with environmental issues. The one that we've been talking about a lot more often is the rules from COSPAR, which some of the technicians are aware of, where let's say different missions are classified. And depending on what the mission is and where the mission is towards, you have to take certain precautions to make sure there's no contamination of the planet or the celestial body itself. And likewise, there's no reverse contamination. So that's, let's say, the more biological part of it. And then, of course, you have the question on polluting the Earth's orbit. That's more of a serious problem than everything else. So for space debris as well, we don't have a specific law, but then we have guidelines that have been adopted by different government agencies, by industries, and so on. And this happens with several stakeholders in play. So you have the ISO, the standardization organization that's prescribing how missions should be built, what happens when satellites reach the end of mission. So if they are in the geostationary orbit, they get pushed to what is called a graveyard orbit. That's a bit temporary, but still it gets moved away so that you could put another satellite in its place. If they are in the low Earth orbit, then it is mandated that they are brought down into the atmosphere within a certain time. So that's another sphere. And then, of course, you also have the sphere of the planetary body itself getting polluted. And the Outer Space Treaty mentions in one of its articles that we need to prevent any sort of harmful interference. So whether it's with activities that others do in space, so let's say there are conflicting missions, or in general for the environment, that we don't create an adverse impact on the environment. How this will actually be done in future, that's something where details need to be chalked out. But since the discussions in the other spheres are let's say, are topical, the fact that if we have these 95 missions go in, it will be addressed there as well. So it's not something, it's something that I worry about, but it's not something where I think nobody would do anything about it. Antonino, to you?
Yeah, I mean, I obviously agree with you. Environmental protection in space is certainly a topic of concern, which is getting more and more relevant as we are aware of what we're doing. I think concerning polluting space with, the emissions of space launches, this is a conversation that we need to have in the broader context of, climate change and polluting environment. Of course, space launches are a source of pollution, but they're not the only one. In the meantime, we're still driving every day our car, which is polluting the environment. So we're not saying that we shouldn't drive anymore. So I think there should be a coordinated approach to make sure that these launches pollute as less as possible. But in the meantime, we should also invest in technologies that will help us do so. But this should be part of a broader conversation, not just focus on space launches just for the emissions. Then for debris, that's a specific problem of space. And of course, we need to address that properly. I think we're making steps to do so, but it's a long process, I'm afraid.
Okay, yeah, thank you very much. A few smaller questions have also come up, but we already ran out of time. We're already over time, so I was asked to end the discussion. I know that you probably still have a ton of questions, and I do. I've actually still written down a few, but I think maybe we can continue that on a private level through email or whatever it is, or maybe LinkedIn, or there are so many websites that help. So thank you very much for your amazing contributions. It's been so much fun. And I personally learned a ton, and I think it was a very, very good way of discussion also with this framework that Deepika has created. So it was a great pleasure to have you all here. Thank you very much, and I hope to see you all again tomorrow. Thank you.
Yeah.
Thank
Bye,
you.
everybody.
It was a pleasure being here.
Good.
And
Bye-bye.
congrats to the organizers.
Thank you very much, everyone.
America, Europe.
I really, really appreciate your contributions, and I think it just goes to show that space exploration is a team sport, that we all need each other, and I think the wonderful collaboration that we've established even in this short time is such a positive thing. So thank you once again. And for those of you in Europe, enjoy your day. For those of you in Australia, sleep well, and we'll hope to see you tomorrow. Thank you.
Tomorrow.
Couldn't agree more, Rowena. Thank you very much. And look forward to continuing this discussion. Bye.
Bye.